Hello everyone, welcome back to the channel. This presentation is brought to you by Synergy Business Advisors, Noida, your trusted business mitra, providing complete advisory solutions. Today we are discussing a landmark judgment by the Madhya Pradesh High Court in a major bank fraud case and what it means for corporate promoters, directors and ongoing PMLA investigations. The case involves massive rupees 1400 crores alleged fraud by Mr. S. Kumar's Nationwide Limited, where bank loans reportedly turned into NPA due to irregularities. Following CBI investigations under IBC and anti-corruption provisions, the Enforcement Directorate stepped in under Section 17 of the PMLA 2002, which allows the ED to conduct search and seizure operations if there are reasons to believe that any person is in possession of proceeds of crime. On December 23, 2025, the ED conducted searches at the premises of Mr. Nitin Shambhu Kumar Kasliwal, former chairman and MD of SKNL. Mr. Kasliwal challenged the legality of the search and seizure in the Madhya Pradesh High Court Indore branch. Before we move further, let us quickly understand Section 17 of the PMLA. It empowers the ED to search any person, property or premises if it has reasons to believe that money laundering or possession of proceeds of crime is involved. The law requires that the reasons to believe be recorded in writing and communicated to the adjudicating authority. Importantly, Section 17 allows preventive action. This means the ED can act even if the underlying criminal case or FIR is still pending or stayed. Petitioner's contentions in this regard were: the petitioner argued that the ED acted on mere suspicion without valid reasons. There was no proven predicate offense or proceeds of crime. The underlying FIR was stayed, so the ED action should also be stayed. The ED's action were retaliatory, allegedly motivated by mala-fide intent following previous court orders. ED's response was: the ED defended its actions, stating valid reasons to believe were recorded and communicated to the adjudicating authority as required under Section 17. PMLA proceedings are independent of the underlying FIR or their status. The petitioner has statutory remedies under PMLA. Objections can be raised before the adjudicating authority under Section 17. In other words, the law provides a clear process for the petitioner to challenge the search without immediately approaching the High Court. High Court's decision. The High Court dismissed the petition. The court noted that objections can be raised before the adjudicating authority, making premature High Court intervention unnecessary. It reaffirmed that PMLA proceedings are independent of any stay on underlying FIR. The court also found no credible mala-fide allegations against the ED and assumed that all procedural requirements, including reasons to believe, were properly recorded. Key takeaways. So, what does this mean? First, the High Courts are cautious in interfering with ongoing PMLA proceedings. Second, the ED's authorities to conduct search and seizure in major bank fraud linked money laundering cases is strengthened. And third, corporate promoters and directors must exhaust statutory remedies under the PMLA before seeking High Court relief. In short, the judgment emphasizes that the independence of PMLA actions and signals that early intervention by court is limited unless there is clear evidence of mala-fide conduct or procedural lapses. This is a wrap on this important MP High Court judgment. For corporate directors and professionals, this is a reminder to stay compliant and be prepared for statutory proceedings under PMLA. This is CA and IP Praveen Agrawal thanking you for watching. I hope this presentation will be helpful for you. Please subscribe to the channel for more such informative videos. Thank you.